Okay, thank you for joining us today. This is the fourth installment of our series on regulatory issues related to telemedicine and medication abortion in the wake of the Supreme Court Dobbs decision. The topic today is the intersection of privacy and telemedicine. Before we get going, I'm Harry Nelson. I'm happy to be with you for this presentation today. I just want to include the disclaimers. Apologies, as a lawyer, I feel obligated to do this, that this is intended to be an educational program. It's not intended to be legal advice. I'm presenting my opinions and not the opinion of any outside organization. If you're worried about what to do in a particular situation involving a privacy issue, we encourage you to speak to an attorney. Okay, this is, as I said, the fourth of a series that we've done until now. I just put these up there for anybody who's joining for the first time. If you haven't had a chance to hear these, they are available. The key way to get them is to reach out to our marketing coordinator, our marketing manager, who can provide them to you. So there'll be instructions on the very last slide, and we're happy to make these slides available if you simply email us and let us know that you would like them. And likewise, this presentation will be available, is being recorded and will be available. Okay, so I want to just give a little preface. The topic today was the intersection of privacy and issues around telemedicine and medication abortion. And I want to just say up front, this is going to be a presentation that raises more questions than it answers. My goal for today is really to offer a framework for the issues that providers and patients need to be thinking about some of the work that needs to be done on the individual provider level within healthcare organizations and at a legislative and regulatory level. So with that, let's just jump right in. So the first thing I wanted to do, apologies to Raymond Carver, I wanted to address what we talk about when we talk about privacy and data security. And the reason that I listed this first is that I think the conversation today and the way that I mean to talk about privacy and data security and the way that the Dobbs decision forces us to rethink it, take us beyond the normal or sort of conventional ways that we frequently use those terms. So just to sort of take you back to kind of basic concepts in healthcare and privacy and data security law, conventionally, we use the definition, and I'm using HIPAA here as a reference point, although this is true of essentially all healthcare privacy laws at the state level as well in the United States. When we talk about the healthcare privacy, we're talking about the practices that providers and their workforces undertake to maintain the security and confidentiality of patient information, patient records. Right, the privacy rules, if you look, for example, at HIPAA, are really rules that try to impose some limitations and discretion on providers in how they communicate and protect the security of medical and patient records. I included the scope of the HIPAA privacy rule here. I'll talk more broadly about the way that HIPAA is just a narrow piece of this conversation that we're going to have today. But essentially, it refers to any individually identifiable health information that is held or transmitted. We'll talk about covered entity in just a couple slides, or a business associate, and whatever form it is, right? This could be, health privacy applies to what patients say to providers, what providers write down, whether they do so in any media whatsoever where information is stored. Likewise, when we talk about health data security, we will often talk about really protecting the electronic aspects of information. So we often use like protected health information, or PHI is the frequent designation that we give to protected information under HIPAA. And when we talk about health data security, we talk about ePHI, all the information stored in databases like electronic health record system, for example, information that's transmitted. And the rules of data security ordinarily cover how that information is transmitted. And in many ways, what I want to say today is that the issues presented by the Dobbs case and what it means for privacy and data security have kind of opened the eyes of many people, including me, as to just how broad these questions go, and what how insecure our health data is in this moment in time. And I put here a series of broader healthcare questions that I want to pose today. I'm going to answer these questions a little bit. I hope my answers are a starting point. I don't think they're going to be the last word. And I hope that there'll be more presentations, whether we put them on or other folks do, just to get really into the weeds here, because I think this is really a critical topic. Okay, so the questions I want to focus us on, as they relate to medication abortion, abortion more generally, by telemedicine or in other settings, and privacy and data security are as follows. How much can patients and clinicians secure information and be selective about how they record it? And I'll say more about that in detail. To what extent can patients and clinicians, and I'm using the term clinicians to be inclusive of not only physicians, but nurse practitioners, physician assistants, and every provider who's involved potentially in an encounter with a patient relating to their reproductive health rights. How can patients and clinicians respond selectively, or in some cases object and refuse to cooperate with inquiries that may be coming as a result of the Dobbs decision from hostile state law enforcement, investigators, and also, it's important to remember, from private parties who may be using bounty hunter, private attorney general statutes in places like Texas to push for information. I want to ask the question about provider-patient privilege and confidentiality, which, by the way, those terms mean different things. How far does clinician confidentiality extend over everything that's said, everything that's done in the patient encounter, everything that's recorded? What are the limits there, right? I want to try and start with a little bit of what existing laws, both federal and state, protect and threaten privacy and data security. And I want to ask a question for anyone who's listening, who's thinking about the advocacy work and the legislative and regulatory work needed ahead. Where do we need new laws to protect the social boundaries of what we don't want other people to know? And so it's a broad agenda, ambitious agenda for the next 40 minutes or so, but hang in there with me. Okay, let's get to the heart of the matter. What I want to say first is that what we're really talking about today is kind of different from the way we normally, as a healthcare lawyer, think about healthcare data privacy and security. The Dobbs decision opens up the potential for states, which I'm going to call hostile states that are hostile to abortion rights, to use criminal laws, prosecutions, as I mentioned, civil cases as well, private attorney general, bounty hunter cases, to override privacy and reproductive health protection, right? Some of the ways in which we now have to think about those laws being used, or those efforts being made, is for attempts to be made to potentially use a patient's health record to support a legal action against a patient or a provider for the act of seeking an abortion, obtaining an abortion, or, and this is particularly true of all the providers involved, aiding and abetting an abortion, right? There's that potential use, which is really a new kind of issue that that as a lawyer dealing with health data privacy, we haven't really had to reckon with before. We have the potential use of healthcare facility records being used to incriminate the institution or its clinician for providing abortion services. We've seen, for example, many hospitals and other healthcare facilities that are reluctant not only to provide abortion services, but to provide unrelated reproductive health services simply because of the fear of how they may be incriminated, or questions about whether a patient is sick enough, whether you have to wait for someone for their health to be more endangered in order to render care to avoid incrimination for the facility. And finally, a risk of information that's being generated from a person's digital footprint, right? Your online activity, how much can that be used to show that you may have sought an abortion or helped somebody else to do so? That's really what I would call the heart of the matter. I now want to take a step back and kind of go back to what we have to deal with in terms of an infrastructure, if you will, on a legal and regulatory level to protect healthcare. And I think this moment lays bare the extent to which our system is really not up to the challenge that we just described. So I started my private practice career in 1994. I graduated law school in 92. So I grew up with HIPAA as a lawyer, as a healthcare lawyer. And I think it's important to say something about how HIPAA is really limited, right? It's very specific. The point of HIPAA was to begin to create national standards to protect sensitive patient health information from being disclosed. Before HIPAA, we were talking about laws that nobody even really uses in many contexts, like the Family Educational Rights Privacy Act. There wasn't much there before. But the important thing to note about HIPAA is that in order for there to be federal jurisdiction, the drafters of HIPAA made it only applicable to two categories of entities: covered entities and business associates. And it also applies, of course, to the workforces of covered entities and business associates. Covered entities are three categories. They're health plans, they're healthcare data clearinghouses, and they're healthcare providers who transmit claims for payment electronically in connection with healthcare transactions, right? So really, ironically, HIPAA does not actually fully extend to all healthcare providers. If you're not a provider whose organization is submitting electronic payment claims, it doesn't actually even apply to you as a provider. But the more important point to make here, by the way, I'm not going to talk about business associates at length. Those are just the people who derivatively receive healthcare information in support of covered entities on behalf of them. As a healthcare lawyer, we're constantly in cases where we have to get data from a healthcare provider. And so we sign a business associate agreement, basically taking on the same responsibilities to protect the data that's transmitted to us. Okay, but the important point I want to get to here is that HIPAA is full of exceptions. And I'm quoting directly from the enacting law, which says nothing in this law shall be construed to invalidate or limit the authority, power, or procedures established under any law providing for the reporting of disease or injury, child abuse, birth or death, public health surveillance, or public health investigation or intervention. HIPAA is full of exceptions where we say, oh, these privacy restrictions don't limit the following kinds of activity. And those include public health investigations and law enforcement investigations. There's an exception for court orders. So if you are thinking about how HIPAA protects, frankly, in a hostile jurisdiction where a court may issue us an order or where law enforcement may issue a subpoena for records, for health records, or law enforcement is conducting a review, HIPAA, you can assert HIPAA, but it's questionable. It's very likely that HIPAA may not actually protect you. And I want to talk about the guidance. The administration is obviously, currently trying to put out as strong a position as it can, but if you read the guidance being put out, it doesn't say that providers cannot produce information. It really talks about providers' right to be selective about, and the providers aren't forced to respond to requests from hostile states. HIPAA really is not a sort of a secure barrier to protect people against the incursion into health data privacy. It's important to also just point out there are a number of other federal and state laws that are relevant to the questions of health data. The Federal Trade Commission, which I'll talk about a little bit later, oversees the relationship between consumers more broadly and healthcare providers. It has certain rights to intervene in certain cases. It has actually already, since Dobbs, intervened and sued a data trafficker, and I'll talk about that. And a lot of, as I mentioned, because HIPAA is limited, often we have to look to state health privacy laws, which apply more broadly, that don't have that narrow federal jurisdiction issue with covered entities that I referred to, and which are broader in their scope, but not necessarily more significantly protective, right? If you look at state health privacy laws, you see the same kinds of exceptions. Nobody imagined that court orders or law enforcement investigations could be used in a way that was antagonistic to get health data to potentially investigate and prosecute patients or providers. The laws weren't set up that way, and so none of these laws are that protective. Also, we have state consumer privacy laws that have, have grown in scope. We have a number of states now following the model of California, which was the first state to adopt a European-style, a greater level of consumer protection. Also, I would just submit, I'm not going to get into the detail of them. I think it's beyond the scope of this presentation, but they're not that protective here. So the first question I want to just ask here is we need to ask what new laws may be required and what laws in particular states may want to be thinking about if they're really looking to be protective of privacy and to set a new social boundary of what information is attainable. The question may not be resolved simply by a state doing so, because you may have interstate challenges, but there's a lot more that states that are permissive and supportive of reproductive health rights, a lot more they could be doing and they could do. And I think that's an important frontier for anybody interested in advocacy on this issue to be thinking about. Okay, I want to come to my second topic that I wanted to raise, which was the challenge that the anti-abortion threats pose to our current paradigm of medical privacy. We have been getting we've been getting a lot of information, not complaints, but providers. Most of our information comes from providers, so you're getting a particular, a very anecdotal presentation here. This is not coming from broad research. I'm just sharing experientially what we're receiving and trying to share it because I think it's helpful. The biggest piece of feedback that began coming immediately after the Dobbs decision was that patients are coming to providers with a deep and serious concern about the privacy of the information that they're sharing, right? And what are the risks to patients if their information makes it into the wrong hands? As you can imagine, clinicians, and I assume many clinicians on this presentation, are really concerned with their own licensing risks, as well as the risks to their patients from information leaking out to anti-abortion advocates. For example, if a person who gets access to the information somewhere in the chain of transmission, even within healthcare channels, from going from physician to pharmacy, for example, if it gets to somebody's hands who is essentially a supporter of anti-abortion efforts, what risk is there? We've seen, of course, the questions that we addressed on our last webinar about employers and payers who may be at risk simply for covering abortion or abortion-related costs like travel. Questions about the power and enforceability of hostile state subpoenas and demands for information. Questions from entities that store health data, right? I mean, the largest. We'll talk about the large electronic health record companies, but for example, Google is taking some action because it's aware that its search data alone is a massive repository of health data information. I haven't seen anything yet from Amazon, but their Amazon Web Services is holding massive amounts of health data, and there are questions about what the responsibilities and what the risks are there. As I mentioned, the role of third-party data brokers, I believe the Dobbs case has shined a real light that many people weren't paying attention to of what's going on in terms of the way information is being packaged and sold, and the way that reproductive health information may be included in that. And finally, I would just argue a demand for a new ethics of abortion privacy, not just new laws, but really a new ethic of privacy. I think I'm not going to, again, beyond the scope of this webinar, but I just want to highlight this point. Fundamentally, the Dobbs case represents a major narrowing of privacy rights in the United States. The original decision in the Roe v. Wade was that the right of abortion was grounded, the Supreme Court, a majority of the Supreme Court held, in the right to privacy, originating from the 14th Amendment and from a concept of personal liberty that encompassed the privacy of a woman's choice whether or not to terminate her pregnancy. And so that was the historic reason a lot of People have questioned whether the right could have been grounded otherwise, but that's how it was grounded. And so the Dobbs decision stands for the point that the scope of privacy, the right of privacy, is substantially narrower, right? It no longer protects abortion, and states are permitted to restrict personal decisions and medical options available or related to abortion. So there's a big question beyond the scope of this webinar. I just want to put it in to make sure we kind of hit the things people should be thinking about of how far the right of privacy already has been undermined, eroded, and how far it will be in the future. The overriding question that we have received, again, purely anecdotal, has been just this question of a chilling effect on the clinician-patient relationship. Patients in hostile states don't know at this moment what they can discuss with their clinicians, what's going to be recorded, what could come back to haunt them. That's in terms of action they've already taken with regard to abortion, attempts, contemplated plans. There's this whole question, right? Clinicians are asking, can we treat this patient? How candid can we be in giving advice without potentially putting ourselves at risk of aiding and abetting? As I mentioned, this new question of, is the patient sick enough to take action? Do we have to wait for a patient to be more ill and more seriously at risk to take action? Risks of downstream abortion provider reporting, and fundamentally an undermining of a patient's ability to make informed healthcare decisions. If in a situation, we've created a situation in which patients need to really think carefully and are legitimately going to be reluctant to share their medical histories, and doctors are going to be, and other clinicians are going to be wary about what they can and can't discuss. Can a doctor in a hostile state even disclose and mention other options, right? Options out of the United States, options in that are available digitally, and the option of traveling to a different state. A whole new set of questions. And again, this other overarching question: can law enforcement demand access to records, to provider information? What if they do? What I want to say here is that it's critical both for patients and for providers, who are working with other providers, to understand what information is being recorded, where it is being recorded, and how providers are going to respond to inquiries short of search warrants, and how they're going to assert their rights to object and refuse. I want to say a little bit more here. The search warrant is sort of the apex of the level of search that a law enforcement organization can make. When a search warrant comes, a judge has already authorized law enforcement investigations and prosecutors who are making a case to come with a document that entitles them to search and take a right to take paper records, take computers. That's an extreme example. Your rights when a search warrant are issued are dramatically reduced, right? At that point, there's already been a judicial decision to allow law enforcement to get information. The vast majority of the requests and subpoenas and court orders that are going to come to providers are going to be below that level. And that's where the questions come in of how you respond to them. A subpoena, offers many more options of response, right? The first thing that anybody who receives a subpoena needs to do is to ask, is this subpoena lawful? Was it appropriately obtained? And then the question of, how do I respond to it? Do I have a basis to object or refuse? And I think it's very important to educate people about their right to object. I just want to make an analogy. One of the things that really stuck out for me in law school, in criminal law, as a first-year law student, was you learn about the right of the government's right to and the protection against the government's right to search and seizure under the Fourth Amendment. And one of the strange places, one of the things you learn as a young lawyer is that you have to be tougher than an ordinary person when the government asks if they can search your bag or your car. And most people just say, of course, and consent. And that if you read the Supreme Court decisions, they effectively require people to be tougher than what might be ordinary, right? The ordinary person presented by law enforcement asking to conduct a search might say, their tendency would be to say, here you go, officer. You actually have to be tougher and to refuse in order to assert your rights, right? And you have to be unafraid of that conflict. And I want to say that we're in an analogous circumstance here, where as these subpoenas come, and they are coming and they will come, providers need to understand their rights. They need to think about how to object. And I'll just share with you, not in the abortion context. I think it's just a story that may be helpful. We had as state laws have changed around going from synchronous live video telemedicine to authorizing asynchronous care. I had a situation on behalf of a telemedicine provider years ago where we read a state's laws, and the state appeared to be permissive of asynchronous telemedicine, meaning no live contact, just essentially transmissions of data back and forth between the provider and patient at different times. And so we blessed a telemedicine platform to go asynchronous in a particular state. The state learned of this provider's activity and sent a subpoena asking for patient records to find out what was going on. And as you can imagine, that wasn't good news, because it suggests that the state thought there was something wrong being done. And sure enough, when we dug a little deeper, we realized that the state had passed a new regulation, and all of a sudden was much more restrictive on asynchronous care. And so the response that we elected in that case was to write back and say, thank you for your subpoena, but we are not providing these records. We object. We do not believe you have the authority, and we asserted privacy rights. And it was kind of you end up in a little bit of a standoff. And in that particular case, we were able to negotiate, and we basically said, listen, we're not going to give you the records, but we will pull our app out of the Google, the Android and iPhone store from your state. So we won't be in your state until we've taken a better look at your laws and assessed it. And the medical board in that state said, okay, and the matter was resolved, right? If that hadn't been enough, the next step would be for law enforcement to go to court and say, no, we're entitled to those documents. And that's a point that's going to be important for providers to assert, to not be afraid to make those objections, even though it will mean involving courts. And I'm going to go a step further and say there may be cases where courts rule in favor of law enforcement agencies, and courts often, in my opinion, these are tough cases, and courts often make decisions that are questionable. And there may be cases where providers are put in a position of having to decide not to comply and being at risk of contempt, right? That's still an exercise of your rights as a organization, as an individual. It may mean there may be consequences, but these are the kind of choices that are going to need to be made. And my point here is not to answer. This is a decision. These decisions of how to handle these issues are going to need to be made on an organization by organization, provider by provider level. But I think it's important to think about them. It's, number one, important to understand your rights as a provider. It's important to be able to educate your patients, and it's important to think about this and ideally memorialize it in policies and procedures and training, so that everybody in the organization understands how to respond to requests for information, subpoenas, every step of the way. There's really a new urgency, in my opinion, to think about this issue. Okay, I want to shift gears and talk a little bit about some practical things that in the clinician-patient encounter and in terms of clinician, provider behavior and patient behavior, things to think about changing in light of the new risk environment. So I said I was going to come back to this concept of clinician-patient privilege, clinician-patient confidentiality. Just to be clear, if you're going out there and looking for information on this topic, when people use doctor-patient privilege or clinician-patient privilege as terms, they're generally referring to historically the principle that I believe in every state, there were certain communications, certain things that a patient would convey to a provider that could not be used against the patient in court. I made the comments previously about the nature of exceptions from law enforcement investigations being really a limitation on the value of HIPAA as a bulwark against patient privacy, and that's also true here. Law enforcement investigations and court orders will kind of override and trample on clinician-patient confidentiality in the hostile states. The point I want to go beyond in terms of clinician-patient confidentiality is that I think there's a broader meaning and importance of confidentiality beyond the narrow question of what a particular state would view as a protected communication that the provider would not be required to share. And that is that providers have an ethical and potentially, and you have to go state by state here, a legal obligation to safeguard any information that a patient shares and hold it in confidence so that patients don't withhold critical health information. That's right there in the AMA Code of Ethics. And I originally, when I wrote this slide, I used the term conscientious objection, and I actually stayed away from it because that term is often used in the anti-abortion world to talk about people who are refusing to participate in abortion care. But I think there is actually a conscientious issue of where your legal protection as a provider ends and where your ethical responsibility begins. And we're really in a tough moment, and I don't have an answer. I'm just putting this out there. The clinician's ability to recommend, provide care, and inform patients in the patient's best medical interest, which is the duty of the provider, are really threatened in the new environment post-Dobbs, and it's an issue that needs to be reckoned with beyond this particular webinar. And I hope that there'll be more to say about that. But there's a lot of work to do to shore up the right of clinicians to advise patients, inform patients in this area. Okay, some practical considerations for clinicians. As I mentioned previously, I think it's really important for providers to think about how they're going to discuss privacy issues with patients, what assurances they can give to patients. And you can only do this if you yourself as a clinician and as a provider organization have clarity on how you're going to respond, right? I think this is really an overriding need that's emerged post-Dobbs. I think there's a real conundrum for providers, for all clinicians, right? If before we got to the Dobbs case and the threats related to abortion care, as a healthcare lawyer, we were always kind of, pounding the table, telling providers to document more, because when you look at licensing boards, for example, the single biggest risk that providers face from licensing boards. By the way, this is like the kind of speeding ticket equivalent of all licensed health professionals is inadequate record keeping. Right? If you don't keep adequate records, in the old days that used to mean sloppy handwriting could get you disciplined by your licensing board. In the post-digital age, simply using cut and paste style records can get you in trouble. Right? There's a real question of what is adequate record keeping and what's the minimum necessary information you need to provide to protect yourself against your board, your licensing board. Likewise, you may be a part of a healthcare organization that has standards of minimum levels of documentation. And of course, there's always the professional liability malpractice risk that compels doctors to write things down. The fundamental rule, kind of unwritten rule, but rule across the healthcare universe has been, for providers, has been, if you didn't write it down, it's as if it didn't happen. I must have said that 1,000 times, 2,000 times in the last 20 years. And so that was the starting place. And all of a sudden, we're now in an environment where writing things down may be risky for the patient and for the provider. So I think there's a new consideration of what gets recorded. I'm going to jump over one of my points. I'll come back to it on cloud-based databases. At a minimum, certainly it's worth considering as a provider whether to limit details to the absolute minimum necessary, right? By the way, on our previous 2 webinars ago, we talked about laws that require verification of patient identity and authorization. So those kind of laws require providers to start documenting things that otherwise could protect patients if they weren't in the record, but states are requiring that information. But some of the things that are certainly not called for by any law and that providers might consider omitting from the record are past patient actions, patient motivations or the reasons for seeking abortion care, the purported paternity. Those are not things that need to necessarily be in the record, and it's worth providers thinking about how spare they can be to meet their responsibilities, and that's an important question. The other thing, and I'm going to talk more about, I want to shift into the digital topic because I think this is really something that nobody has given great thought to, is whether you should be using cloud-based databases and how records should be transmitted. That is, how records should be stored when it comes to record keeping, and also how they get transmitted, for example, to pharmacies. Or I'm not applying this to the payer question, but I think this is a fair question because pharmacies have been a real point of vulnerability. We're seeing pharmacies and pharmacists refusing not only to fulfill orders, not even abortion medications. We're seeing like Plan B and other kind of contraceptive post-coital contraception that's being rejected. We're seeing all kinds of other incidental things where pharmacists are refusing to provide information, in many cases not because they're hostile, but only because they're afraid, right? Or demanding patient fetal heartbeat before giving Plan B medications. Really like a new environment, and so it raises the question of how information is being stored. All right, I'm going to come back to that topic, but I want to just get to the some of the recent federal activity. Okay, right after the Dobbs decision, June 29th, the Department of Health and Human Services, Office of Civil Rights, came out with a guidance statement. It was intended to be supportive and essentially to kind of strengthen the rights of providers, and but I think I think anybody who looks at it is going to struggle to see how it really is a game changer. What it really does is it highlights that even now, with a presidential administration that is supportive of reproductive health rights, how feeble our privacy laws are, right? So this guidance statement discusses where a pregnant individual in a state that bans abortion informs a provider that they seek an abortion in another state where abortion is legal. Is that information is that information discoverable? Does a provider have to provide it, right? So the position of the Office of Civil Rights, which is the unit within the Department of Health and Human Services tasked with enforcing HIPAA, is that the privacy rule does not permit a provider to report such a statement. For example, that a patient is going from a hostile state to a permissive state, that it does not permit the patient to provide that statement, right? That's a privacy violation. We'll see if there'll be enforcement in the case of providers who do that. Frankly, my assumption is that most patients are going to go to resources where they're not worried about that, but it raises a whole another kind of trail to go down of how challenging this moment is. But OCR offers a number of scenarios. I've listed one here, and like the scenario I listed here was a law enforcement official presents a reproductive healthcare clinic with a court order requiring the clinic to produce a health record about an individual who obtained an abortion. And so the point of the Office of Civil Rights wants to make is the privacy rule permits that, but doesn't require the clinic to do it, right? That what the only thing that's really being said here is that you have the right to object. It certainly is not saying that you are prohibited as a healthcare provider from disclosing that information. So to me, it just highlights that there is an option here for providers, but not there's no guarantee. You've really got to use your rights and assert your rights, as a provider. Okay, really, really interesting. I actually think this is the more significant thing to come out of the government. It was the same day that they put out the previous guidance on the privacy rule. They also put out a personal device guidance, right? And so this should be a wake-up call for everybody, everybody in this country. The government's statement here is from the Office of Civil Rights. The HIPAA rules do not protect privacy or security of individual health information when it is accessed or stored on a cell phone, a smartphone, just any kind of personal cell phone, or a tablet, right? HIPAA does not apply to protection of geographic location information, internet search history, information that people voluntarily share online, or data entered into mobile apps, unless a covered entity actually provides the app, right? So basically the government is saying, watch out, this is a major danger zone. And everybody should wake up to this and consider how they are using data and how your organization is processing data. For telemedicine providers, for example, this highlights the need to consider limiting the use of tracking technologies such as location tracing, transmitting data to social media platforms that may be embedded in websites, right? And search data, what you're doing with search data, right? Google, as I mentioned, actually announced that it was deleting certain kinds of search data from its databases. I included a link here that I really encourage people to look at. This is a link that the government put out, basically giving instructions of how to change the settings on your iPhone or your other device to turn off location tracking. So if you do not want people to track your location, right? Likewise, personalized ads. All of the advertising is really flowing from all of this collection of information. There's going to be a lot more work here ahead to really establish good practices, but this is a major, major issue. I just wanted to share a few headlines that are really just kind of highlight what a big issue this is. So first, on the left side, as I mentioned, data brokers, data traffickers. So Kochava is a group that was sued by the FTC. They are one of a number of companies that collect data, they aggregate data, mobile data from your smartphone and from your computer, and they use it to track information, right? They buy huge volumes of location data. I just made some notes before, and they package it and they resell it. So usually they resell it to advertisers, right? This is why we get hounded. Anytime you look for anything on your smartphone, you're guaranteed to be followed and see ads for that thing over and over again. They collect data on a weekly basis from 61 million devices, and they record on a week. I believe this is weekly. It might be it might be daily. 94 billion transactions, right? That must be a longer time period. But the point is, the FTC sued them because they basically found a case where it was possible to trace an individual user to a particular reproductive health clinic, and so they've sued Kochava, and it just highlights these data brokers are out there collecting information that all of a sudden could be useful to law enforcement. There was the case in Nebraska where the police acknowledged that they used Facebook data in the course of an abortion investigation, and we had Apple coming out with this new watch, and all of a sudden people asking questions about whether fertility tracking was going to be a nightmare in the Dobbs era. So cloud-based data is a massive investigational resource for law enforcement and parties suing in hostile jurisdictions, and it really requires a rethinking of how you search, what data you allow to be out there. I wanted to put this slide up. I'm not attacking any of these companies. I'm not criticizing these companies, but I wanted to share a couple of stories with you that I think are instructive. I hope are instructive on some of the issues here. So first, just to give you a picture of how much of our health information is in electronic databases that are cloud-based, right? Epic is a hospital-based software. It's probably not the software that most telemedicine providers are using, but it holds 78% of the records of 78% of the patients in the United States, right? Providers who use it share 100 million records per month with each other, with other providers using the system. Epic is certainly not the only large provider, but it raises questions when we have these cloud-based platforms that integrate lots of different providers into a network, how safe the information is and who's making a decision about how to release it, right? It opens up all kinds of possibilities that as a provider, you might put information into a database that you won't control and that somebody else will be able to see and release information on. And likewise, SureScript, which a lot of telemedicine providers are using as their e-prescribing software, is probably the leading software that's embedded in many telemedicine platforms, and you know, is out there likewise, providing a lot of information and that transmission from the provider to the pharmacy. And I want to talk about DoseSpot, and I don't mean anything negative about DoseSpot, but I think the stories I want to share about DoseSpot are not intended to criticize DoseSpot, but to highlight the conundrum that we're in. A few years ago, I was in a medical board investigation for a telemedicine company that was being questioned for using a particular asynchronous modality. It had nothing to do with abortion. It was having to do with a different condition, much more widespread health condition. But the investigation was questioning whether, was questioning whether asynchronous was appropriate as a modality of telemedicine, and what safeguards. The question came up in the investigation: what safeguards was the telemedicine provider taking to actually to know that the patient was giving reliable information? And so DoseSpot in that setting was an incredible answer, because the provider who I was with was able to say to a medical board investigator, well, when I get a patient in our system who asks for a particular medication, let's say a blood pressure medication, I can go on DoseSpot and I can see that this patient has been taking this medication since just let's say 2015, and they've been getting it from these other providers. And that tells me that this patient is a legitimate patient, right? Other providers have been giving the patient this information, right? And in that setting, it turns out that DoseSpot was an incredibly important resource for telemedicine providers who were being questioned about the extent to which they could believe and rely upon patients and know that they were giving care safely, right? And knowing what other providers are doing in that context was helpful to the provider in question to know that this was not somebody, there was nothing funky going on here. This was a patient who was taking this medication for a long time, and now they simply wanted to get it prescribed through this telemedicine platform. So fast forward 5 years later, and all of a sudden we're getting reports from multiple telemedicine providers that their patients are coming back upset. And this is again pre-Dobbs, not related to abortion, but in other conditions. Patients are coming back upset because they went to a telemedicine provider for privacy, and they believed that they were getting a prescription filled privately. They were deliberately not using a different doctor that they went to. They weren't going to their regular primary care provider, their regular OBGYN, and they were going to this telemedicine provider for privacy. And then lo and behold, they showed up to see their primary care provider for their regular checkup. And that it turned out that the primary care provider had access to DoseSpot and said, oh, I see you went to this other provider for this other condition. And as you can understand, a patient in that situation feels incredibly violated. Think about how that applies in the context of abortion related medications, mifepristone. Think about how that applies to all kinds of contraception and Plan B and other related, any medication in this zone of reproductive health. And honestly, I don't want to hurt this company. I don't want to. I'm not intending to attack them. I'm sure they're not the only ones out there doing this. But I think it raises a fundamental question of what's okay now. And there was a time when I thought DoseSpot was the greatest thing, because it helped telemedicine providers get some assurance about what patients were doing. And today, I honestly, again, my personal opinion, I see it as dangerous in this context. All right. I want to just give you some final thoughts. I haven't had a chance to look at questions yet, but I'm hoping I'll see them as soon as I stop sharing. Just final thoughts. What I hope people take away from this webinar is that we need to revisit privacy protections as a result of the Dobbs case, and with regard to abortion generally, and certainly telemedicine use of medication abortion, to build a stronger legal infrastructure, to provide clarity, and to protect patients and providers. we need to educate providers and patients on what I this is my term, good privacy data security hygiene, right? That what I mean by that is taking better care of your privacy, of where you are, your actually your information is, like what information is there and how it gets accessed and how it might be accessed. We need for providers certainly engaged in abortion care and in medication abortion to be prepared for potential threats to privacy. I'm strongly recommending that if you or your organization hasn't already thought about and put together policies and procedures about how you keep records, how you respond to government inquiries, and how you educate and inform your patients, there's work to do. There's going to be test cases. This topic is going to need updating. I know this was at a very high level. I think it's the key message I wanted to give out for today is that it's critical to know and assert your rights and to start thinking about this topic. And I hope this is helpful. I see that there are a couple of questions, so I'm going to turn to those. I just want to make a quick share just very briefly that this happens to be Telehealth Awareness Week, highlighting the value of telehealth. We are living through an amazing period in which really the pandemic accelerated telehealth by arguably by up to a decade, of where we were in February 2020 to where we are today, just in terms of the provider adoption, the patient adoption, and there's a lot of work to do. So it happens to be Telehealth Awareness Week. The American Telemedicine Association is celebrating this, and I know that many of the people listening and participating in our webinar series are people who are devoted to telemedicine, and I think it's really important to bring awareness to the issues that we've been talking about in this webinar series around medication abortion. Anyway, so I wanted to share that. By the way, at the very bottom of the slide, we have the email if you want to see, or if you want to get a recording or slides from this webinar or the past one, or answers to questions that were asked. You can reach us there. And so with that, I'm going to stop sharing my screen so I can see the Q&A. Okay. Okay, thank you. Thank you for listening. I really appreciate, I just want to say, I really feel like a community, there's been a lot of gratitude expressed. I personally want to express my gratitude to the entire provider community and advocacy community that is working through these issues. Our goal, we weren't going to be the smartest people in the conversation, but we thought we had a particular niche of expertise to add, and it's really been a privilege, and I hope we can continue doing that. Thank you. There's a comment that Planned Parenthood abilities are onboarding with Epic. So it's a great point, not just hospital-based clinics. So, I didn't intend to attack Epic, but I think, by the way, I have noticed in paying attention to what Epic does, that there are new limitations that Epic has set. There was a point when it was, I believe, easier for a provider who plugged into a system to look at records across systems. I think they're doing a better job of limiting access to records, but it still gives me pause. There's a question here. Can you talk a bit more about the aiding and abetting piece that might apply to telehealth mental health providers? Like if someone wants to talk to a provider who is not their abortion provider about their decision to get an abortion, that's a very, very difficult, you're asking a hard question. Certainly, I think providers, there's a zone in which providers, I believe, and that applies, including mental health providers, have a right to provide information where you're just providing kind of factual information, about decisions. I do worry that if somebody if a provider, including a mental health provider, made a specific recommendation, and certainly if they actually took some action, in the process, that we're not at a point. I hope that when we look forward a couple of years, we'll be able to say that wasn't really a risk. I feel like we are living through a moment where we don't quite know where the lines are, so I'm hesitant to say, oh, there's really no risk to mental health providers. And by the way, I just want to share with people, you know, a lot of the way that I think about this issue has been kind of building on looking in the past at areas where healthcare laws changed. One of the ones that really stands out for me was when states began to decriminalize cannabis, and it remains even today federally criminal. And this question came up about how providers could talk to patients about it. What were the rights of providers? So what came out out of those cases, and those cases are, I think, directly relevant, is that there has been a recognition, not at the Supreme Court level, but at the federal appellate circuit level, of a First Amendment right that providers have, right to free speech. And by the way, that is the underpinning of the whole field of off-label use of medications, is really that the FDA, only gives drug companies and resellers of drugs limited ability. They can only market the drugs for the approved uses, but the provider community has free speech. They have the First Amendment essentially equivalent, and they're allowed to say you can also use this drug for that condition. And so I think that I think there still is a free speech right, but I think that the risk for providers, including mental health providers, comes as you kind of move beyond just expressing your opinions, and you actually start to actively counsel somebody that they should take a particular action. I think the more that you ground it in providing information, sharing your opinions, I think that there is a protection there. I saw a comment that we had disabled the Q&A, and I'm sorry about that. If people do have questions they want to submit after, we're more than happy to share those. There's a question that health information exchanges are another area where data may be secure. It's insecure. It's a great point. The comment in this, I just want to make sure people get this. Someone, I was not aware of this, but somebody who received an abortion in California, and clinicians in Texas could see it in Epic's Care Everywhere, right? Thank you, Care Everywhere. I was trying to think of the name of that software. It's like, that is exactly what I was scared about, right? I thank you to the person who entered this, Dr. Lossie. I'm really appreciative. I think this is a real issue, and that Epic has not fully thought through, and that needs to, until those issues are resolved, and until we have confidence in these digital tools, these resources, these electronic health record systems and e-prescribing systems, we really need to be very, very careful about where information is going. And so I will sign off there. I want to thank everybody for joining us, and I look forward. We don't have a scheduled date for another webinar. We will certainly be doing them. We appreciate feedback on where we can provide more information, and thank you again for listening today.